Yes, welcome to the No State Project. I'm your host, Marc Stevens, author of Government Indicted. Website, of course, markstevens.net or markstevens.net if you're from my neck of the woods. Glad to be with you here from the fortified compound in Mesa, Arizona, as we're here every Wednesday from, I guess it's 3 to 4 Pacific time. I guess it's 4 to 5 Mountain Standard Time. So glad to be with you here, live, commercial free. And I've got a lot of stuff to get to. You want to join me on the big show, you may do so at 218-632-9399, 218-632-9399. And the passcode is 2020 with the pound sign, 2020 with the pound sign or the hashtag. You can also get me on Skype at Frank Rizzo 3, Frank Rizzo with the number 3. So always try to instant message me and don't just call on Skype. That kind of disrupts the show. So, and I want to also remember to thank everybody. I really do appreciate the support for the show. Chris and Matt, Nelson, Eyal. I really appreciate the support you guys do for the show. It really helps. Really helps get things taken care of. If you want to help support the show, you can do that on my sales page or just go to markstevens.net. Remember, Libertopia 2018 is going to be May 3rd. I should remember, May 3rd through the 6th. And it's going to be, you can sign up at libertopia.org, libertopia.org. It's going to be in San Diego, Humphreys by the Bay. Excellent. Just a great venue. And I'll be speaking, and hopefully we'll have that there blues jam. So definitely go to libertopia.org to sign up today. Wow. I was going to start the show off with some good news about California. I do not have the documents, but maybe by the time I get the show, this video posted. So before I get to the calls, which are all from California apparently, Brady in California, again, I don't have the documents for this, but he's got 2 tickets thrown out, each one with multiple allegations of nefarious wrongdoing or code violations. So he filed the demur, he filed the paperwork in both of the demur, the motion for judicial notice, and the discovery request, and all of them were thrown out. So big congratulations to Brady in California for standing up to the predators and getting these things thrown out. Again, as soon as I have the documentary proof, I will get it posted at markstevens.net. And this looks like Orange County, but we've got area code 949. You're live on the No State Project. What's your name? Where you calling from?
Yeah, this is Andrew, calling from Orange County, California.
I got it right there, tough guy. Hey, what do you got for us today?
Actually, I've been watching you for quite a while, and I'm kind of happy to have bumped into you because I've been helping my son with a case, and I've had tickets dismissed with me because I also challenged jurisdiction. I asked them to provide evidence of anything that links us to the codes, but I didn't do it exactly the way you did, and I was really happy to find that you were doing similar, even took it even more stronger stance, which I was really happy to find you. But in our circumstance, now my son is being harassed, and it's a small little speeding ticket. He's on a scooter.
A scooter?
He's on a scooter. Yeah, a scooter. And, sometimes you're going down the hill and there's a hill upward. And so you let it go, you let it glide down so you can get up the other side of the hill. Well, the police were trapped at the bottom, just there going after anybody that allowed their thing to glide down, and just slammed them at that point, and pulled them over and said, oh, we want this, want that. And my son just doesn't give in to anything. He says, I'm not giving you consent to nothing. I don't have anything. I'll give you my name, but that's it. And he doesn't like giving in to any of that stuff. He's trying to be a good son, and stand up for his rights for the first time in his life,
A scooter. So, what is he? Is he 12?
Yeah, a scooter. No, not that type of scooter. It's one of those motorized scooters. It's not a motorcycle. It's not a total cheap scooter. It's like in between. It can go like up to 65.
Wow. Okay. And
You
he
know?
just coasted down a hill.
Coasting down because there's a hill going up, so he wanted to make sure he can get up the other side of the hill without being, crawling. So just as he hit the bottom, he was like about 10 miles over, and then usually when he goes up, it levels out by the time he gets to the top of the other side, and it goes back to normal speed by the time he gets to the top of the next side. But they were sitting right at the bottom in a trap point and just nailed him right there. Apparently, they just sit there trying to nail anybody that goes down that hill.
So let me get this straight.
Yeah.
With all the problems facing people in California, okay, and I'm out there every other week in San Bernardino, with all the trouble that's going on in California with some of the really high unemployment, rampant crime, especially places like San Bernardino. These guys got nothing better to do but to sit there waiting for people like your son on a scooter.
Yeah. It was
Wow.
unbelievable. Yeah.
Wow.
Unbelievable.
Real brief, just to let people know just how much I hate California. I did the opposite this time where I had to go back to California on Sunday because family had stayed out here. So I had to drive from Mesa, Arizona to San Bernardino, which is usually about 5.5 hours. There was a 40-mile traffic jam on I-10. And those who doubt me, anybody who drove on I-10 at all on Sunday will say, what the hell was going on between Indio and Banning? Because it was a parking lot the whole way. And an hour or two later, when I left to come back to Mesa, it was still backed up. But it wasn't quite as bad as that. It wasn't in a dead stop at Indio. But it was still from Banning to almost Palm Springs. So, not only do you pay $1 more a gallon in gas, and yes, you will pay $1 more for gas than you would in Quartzsite.
When you go, 12 cents.
When you go to Blythe.
Increase the tax.
Right, it's the tax. Right, exactly. It's the damn tax. So that's why it's so bad trying to get gas in Quartzsite, because all the people in California okay, so anyway, that was my I hate California for the most part rant. And another reason why. I have never actually been in a 40-mile traffic jam before.
Yeah, it's pretty casual over here because there's so many people here.
Well, and what I was maybe someone could report, was there less traffic in Southern California during the holiday weekend there? Okay, because there was so many people coming back in. Oh my gosh.
There's always traffic every day at different times because everyone's either going to work or coming in or going out from suburbia areas.
Oh, it's terrible.
And so sometimes it's clear, sometimes it's just jam-packed, like for, 10, 20 miles.
Yeah, easy.
At a time.
But 40 miles, this takes the cake. But anyway, so he got a ticket.
So they gave him the ticket.
Okay, what's the ticket for?
Wait,
Andrew, what was the ticket for? What's the actual code violation?
Speeding. Just speeding. Just
speeding.
10 miles over the speed limit.
Okay.
And 25-mile-an-hour zone. This was 25-mile zone. He was going down the hill, so he was letting his scooter pick up speed so he can go up the other side of the hill. Which would be, it'd take him up. By the time he gets to the top of the hill, then his speed goes back to 25. By gliding down and then going up, it makes it easy on a scooter.
Sure.
He's not a car. And so they pulled him over. And a little bike, and of course he doesn't have the commercial tags on the plates. He doesn't, we read that that's what makes the car commercial. So he doesn't like it. He wants it to keep it private under California Commercial Code, which is a personal property. That's it.
No.
So
no,
I know. It gets into other stuff, but anyway.
Well, I have to, just because it's not just a conversation between the two of us, I have to let the listeners, people know there is no merit to that whatsoever. They don't give a damn what you say the status is of your vehicle. private, commercial, military. They don't care. Well, if it's military, it's
Oh,
different.
I fully understand that. I fully understand that. I believe that they ignore their own statutes.
Well,
the statute says that.
No.
It says it.
No, I doubt it says that the operator's license or just the license.
No, it says the exception to the passenger car being commercial is you go to this section. When you go to that section, there's a part in there that says if you voluntarily apply the indicia, that little sticker, then you've agreed. You've agreed to the commercial registration of the car.
I doubt that that's true.
It's in there. I've got it.
You're gonna have to. You're gonna have to give.
Actually, all the codes. I've got all the codes going back from 1925 to current. I have all the statutes from 1925 till current.
But do you have the section where it says you have to voluntarily put that on there to be subject to their code?
Yeah, it's in the previous release of the statutes at large. I'll go ahead and pull it, and I'll send you a copy of that.
You're going to have to, because I'm calling BS on that, because I don't think that's all right. I don't think that's true at all. It goes in line with this whole thing that there used to not be an operator's license when you go back 80 years or more, probably, okay? But they changed things, and that's why
1956. 1956 is when they first changed it to driver's license. Before then, it was an operator's license. But the law specifically said it did not include us. It only included commercial drivers.
I don't think that's true, but I'll wait to see. But I'll take a look at the.
I'll be happy to
send
it to you. I'll send them to you. I'll send you actually all the statutes showing from 1925 to current, and then that'll help you see that all the vehicle code is literally all commercial. The whole entire book is based on commercial regulation.
So why is there a different? Why do they have an operator's license or a driver's license, and they have a separate chauffeur's license?
No. Actually, they changed that. Now if you look at the renewals, I actually have my father's renewal on his, and right on the back of that renewal for a private driver's license, we're talking non-commercial driver's license, it says this is for commercial use only. Right on the back of the renewal notice.
I'm gonna have to see that, because this stuff.
No problem. I got them.
Okay.
I'll be happy to send them.
Hopefully that you're not going to be raising these issues in a motion to or a demur rather.
They did it. The officer kept asking, "Would you like me to put the sticker on your plates for you?" He said, "No, they're fine where they are. They're in their trunk." The officer kept asking him, "Do you want me to put the stickers on for you?" Because they know what they mean.
No, I'm not buying this.
Okay, all right, we'll let that go. But anyway, the main goal is that we do believe in the same thing, that they are required to provide evidence that the statutes apply to you. That the ticket is just an allegation. It's not really any evidence whatsoever. It's just an allegation. But unless they have actual evidence that the statute actually applies to him, and the link, some kind of evidentiary link that links the codes to him, we were going after it on that basis too, except you went a little further and you actually state, does the Constitution or the statutes apply to a person that is in California?
Well, I'm concerned with the Constitution, because the Constitution is the foundation of their laws. That is where the statutes, just like with the Franchise Tax Board. It all comes from the Constitution, so you don't need to discuss. It's a matter of just logic. It's not relevant to discuss the code until there's evidence that the Constitution, the foundation, has been shown to apply. And so they believe that just because we're physically in California, that their Constitution, a written instrument, applies and creates obligations. So the thing is, what you're saying is, you may have actually phrased it that way, but if you're looking at it, that the statute doesn't require that, that's not an issue of evidence. That's a matter of statutory construction or the interpretation of their laws. That's not the same. That's not an evidentiary issue.
Yeah, we did put it on the basis that they have to have some kind of evidentiary link that the statutes exist and apply. Otherwise, they have to exist in relation to him.
Well, they do exist, whether or not. You see, this is a common thing, not that you're accusing me of this, but a common complaint that I have on my YouTube channel is that I claim that the laws don't exist. It's such a stupid thing to say. No, I know they exist. I have a whole book of them out there. I have a hard copy, but whether they apply to me is a different story. So
exactly.
I don't know why you would raise.
Have to apply.
Why raise the question of whether their rules apply when they obviously do?
Well,
why is that a point of contention?
Well, again, see, the allegation is just an allegation. There's no evidence that establishes that there's an injured party, there's anything you did wrong, there was no verified complaint, there was no sworn affidavit, a warrant was it. Nothing exists that links anything to him. It's just an allegation said by some officer that watched something. That's not evidence that what the officer had jurisdiction to begin with, even issue the ticket. What evidence did the officer have that says he had jurisdiction to even give him the ticket?
Right, but I don't want you
linking that.
But I don't want anyone
providing that.
Okay, but I don't want anyone getting caught into this trap that that if there was injury, that they would magically have jurisdiction. That if your son
No. I understand that, but you see, give an example. Let's say like you hit someone's car, right? They can go ahead and swear in an affidavit that you hit their car, you violated them, you hurt them, you caused damage on them. Then it doesn't matter who you are. There is what you call the Constitution only gives power to deal with another party in the state who's hurt someone else.
No.
Not that you specifically are under their law. You're not under their law. But someone is going to sit there. If you hit someone, there's evidence. They have evidence that you hit someone, you hurt somebody. Remember, someone has to be a witness to that. It's hard to get out of something like that.
Well, you don't necessarily need a witness to that. You have, if it's a car that was hit, there's going to be, even if there's no witness, the cars and the street, depending on how it was hit, that is going to be strong evidence to show what happened. But the fact that you get hurt, though, and this is for everyone watching and listening to this, it doesn't matter if I'm not saying, look, we live by the principle of do no harm. It doesn't matter if you do harm to somebody. The Constitution is a written instrument. No one bothered to sign it. Even if they did, they're all dead now.
That's true.
So,
well, that's what I mean. You took it a lot farther than what we did. I mean, I had all my tickets dismissed just by, again, asking for the jurisdiction of where the officer got the jurisdiction to issue the ticket in the first place.
Well, I'm glad you got it. Yeah, and great that they were thrown out. But
they did actually one time. One time I got every judge in Orange County recusing himself because all I asked is that they provide evidence that they're on the bench in good behavior, they haven't had taxes taken out of their check, that they've not lied or concealed or misrepresented anything on the bench. And not a single judge wanted to say that they had complied with the Constitution in any way, shape, or form in regard to that simple little requirement. So every single judge in Orange County recused themselves, and they sent it to Los Angeles.
Wait a minute.
And then they had a Star Chamber hearing without no one there.
Wait a minute.
They didn't tell me when. Yes, they had. They didn't tell me when the hearing was taking place. They didn't let me be there.
Hold on.
They didn't let anyone else be there.
Hold on a minute. You're telling me that every single judge in Orange County recused themselves in a case against you. Do you have the documentation to prove that?
Yes. Yes, I even got the letter from the Superior Court, that the head Superior Court judge of Orange County, where she told me all the judges have recused themselves. At first, I went through 8 courtrooms. When I was at the place, I had a stack of these peremptory challenges with me, and I just kept filling in the judge's name and giving it to him and had my brother serve it on them. And the judge said, I recused myself, and I'd go to each courtroom, and I went through like 8 courtrooms. By the time I got the 8th courtroom, the guy said, we have no more courtrooms for you, so you're going to have to wait till...
Wait a minute.
Response from the head.
Wait a minute.
Judge of Orange County.
All right. Time out here, Andrew. So,
yes.
How did you know which judge was assigned to the case next?
I didn't. I had to wait till I got to the judge, and I put his name on the thing and served it on him.
Wait, this is not making any sense. If you have a judge that's recused, it has to be rescheduled and it has to be reset in front of another judge.
They didn't. They said, we'll send you to the next courtroom.
So they just said, literally, you just go to the next courtroom and that judge is now assigned to your case.
Yes.
And then you went over there and you filled out some paperwork, a challenge or a document to recuse him.
Yeah, preemptory challenge.
And a preemptory challenge. It sounds more like something you do on with a jury when you're doing a voir dire for a jury. So you do a preemptive challenge, and the judge just accepted it and recused it. On what grounds? What were your grounds for all these judges to recuse themselves?
I was asking for them to show that they've been on the bench in good behavior, that they're following their oath of office, that they haven't had taxes taken out of their check, and that they're not biased, that they have not concealed, misrepresented, or anything behind that bench while they're in their tenure. And none of them wanted to provide any evidence on the record before the proceeding began in order to be on that bench.
I'm going to have to see some evidence. This just sounds like a tall tale.
One.
This sounds like a tall tale to me.
Not a tall tale. My whole family was there. I have all my family there witnessing this. It was just the funnest thing I ever saw. But what's worse, check this out. I went in, and not only did the head judge of Orange County send me a letter and say that all the rest of the judges in Orange County have recused themselves in my case. She says, so do I. And this is being sent to Los Angeles. I never received when the hearing was going to take place in Los Angeles. They never gave me an opportunity to be there, and they made some star chamber hearing decision. You know what star chamber means, right? No representation anywhere. They just made a decision without anyone there at all.
Okay, so you have you have documentary proof from the head judge of the Superior Court in Orange County that everyone is recused and that is being sent to Los Angeles.
Yes. And so Los Angeles then made their hearing, star chamber hearing, without me. And then they sent it back to Orange County once they said, you don't have to do this, you don't have to do that, this is ridiculous. But remember, I wasn't there. If I was there, I would have served him the same peremptory challenge. But they wanted to make sure I wasn't there. So they did this hearing in this entire star chamber hearing without me being there. And so I didn't know who was making the decision there, and they made sure I didn't know. So then they sent it back to Orange County. I had to bring a retired judge back in that did not recuse himself in order to hear the case. So then when
wait a minute. What was the decision that the court made, the judge made in Los Angeles to send it?
They said there's no requirement to respond to the peremptory challenge because he used this what you call code decisions, and they had nothing to do with Constitution. I was basically stating you guys are limited by the Constitution. I'm not limited. I'm not under the Constitution. I said I have nothing to do with the Constitution.
But Andrew,
you're limited by the Constitution.
I've got to see some proof of this. This just.
So anyway,
I can't even.
They sent it back.
They sent it back. Wait, real quick. Hold tight just a second. Hold tight.
Yes.
People have tried this before, and there was a famous case. I don't remember the name of it. And what all the courts do is invoke someone did this at the federal level. And it was to recuse all the judges. And it may have been because of they pay taxes, and so they could, all right, whatever it happened to be, they were trying to recuse all of them for bias. They were trying to recuse the entire federal judiciary for the same bias. And so what the court did was invoke the law or the rule of necessity. And they said that and I've mentioned this on the show before, they said, look, if we disqualify all of them, we disqualify none of them. And I'm having a really hard time thinking that the head judge in Orange County signed an order or a statement to you saying that every single judge is recusing themselves because they're not going to sign this preemptive challenge. Where is it even written that judges...
They could not accept the terms of the challenge.
Why would they have to?
Information that was required in the challenge.
But why would a sitting Superior Court judge give a damn about what you've written in there, and why would they have to accept that before proceeding? I'm not getting that at all.
Because I'm just letting you know that they don't sit on that bench as a constitutional at-law judge. It's not at-law. It's an administrative hearing. It has nothing to do with that law. and they know this.
They make rulings on it. You can look at some of the decisions, the things that I've gotten back from judges, and they invoke their constitution, they invoke their laws. So I just don't. I can't.
Remember, they invoke code. They invoke code. But when you get into the higher court, it becomes that law.
Nah, they invoke the Constitution there too. No, they'll invoke the Constitution there also. You can see responses from prosecutors.
No. I've had a judge flash in my face the license in front of my face. Says, "You see this, Mr. Reeves? I can do whatever I want with you. You see, I don't want to use the Constitution in my courtroom in any way, shape, or form."
I get that. So why in the world would he be accepting the terms, or that he has to agree, and instead of just going and telling you, well, I'm not going to, I'm not going to. This is ridiculous. There's no requirement.
I don't know what to do other than the fact that when they sent it back to Orange County, they brought back a retired judge, the one that did not recuse himself. Okay, and then when I went to court, the officer didn't show up, and they said, "Okay, Mr. Reeves, the officer didn't show up, so we're going to dismiss your case." I said, "Nope, I object. I want that officer on the stand. He violated my rights. He took my car. He did all this stuff without any requirement to me whatsoever."
Of course, the judge didn't do that, but that the judge that the judge was retired because you looked it up online, or they told you.
Exactly.
They told you.
And so I told him I object. Give the officer as much time as he wants. I want him on that stand. So we postponed it to another hearing. I come again. Officer doesn't show up. He says, "Well, Mr. Reeves, the officer hasn't shown up. We're going to dismiss your case." I say, "I object. I want this guy on the stand."
Gosh, I gotta jump in. I'm sorry, Andrew. This whole thing just smacks of it.
It's what happened. And by the third time, when I went back, I said, issue a subpoena. He wouldn't issue a subpoena to the officer. He said, "We'll just extend it to this time after his vacation." I come back. By the time I walked in through the doors, I just opened the doors. The judge saw me from the corner of his eye. He said, "Mr. Reeves, your case is dismissed. Get out of my courtroom."
If this is
my family was there.
If this is true,
family was there.
If this is true, why not just ask that the police officer be charged with failure to appear, as you would be, or I would be?
I did. I tried to get it. I tried to get a subpoena issued by the court.
I didn't ask you that.
Not show up.
I didn't ask you that.
You said no. You said no. He wouldn't issue one.
We're talking about a failure to appear. You don't need to have a summons.
He would not issue a subpoena.
He
would not issue a subpoena.
Okay, well.
Even though I requested it. So all I'm telling you is they know that they're violating people day in and day out. They know this.
But they don't care. I get that. They don't care. That's why it doesn't make any sense when you tell me that you just went from courtroom to courtroom to courtroom until you ran out. There's more than just...
What happened. It's what my brother was the one serving each document. I would sign it. He would serve it on the judge. Every single one.
How did he serve it on the judge? Wait, how did he serve it on the judge? I've been to many California... Let me finish. Wait.
Get to the judge.
You talked over me because I've been to California courts many times, and I have mentioned on the show that the sheriff's deputies will advance on you with their hand on the gun if you dare try to get in front of that bar without being a member. So,
he stood behind the bar and said, I hereby serve the judge in the court. And he gave it to the bailiff, and the bailiff gave it to the judge.
I hereby serve thee?
I serve the court.
Did he actually say, I hereby
Here's
serve?
The bailiff, give it to the judge.
This is just getting more comical, but you're going to have to... I still have a line of calls.
I'll be happy to send you the preemptive challenge I used.
No.
The exact language of the challenge, so you'll have it.
Yeah, but it's
what I used. It's what I used.
No, what you need to send me in addition to that.
And I'll get the letter, and I'll find the letter from the Superior Court judge, the head Superior Court judge in Orange County, so you can see this is what happened.
Okay, you got it.
It's really what happened.
Don't bother just sending me the preemptive challenge. Only send the preemptive challenge if you have the documentary proof from the judge that every single Superior Court judge in Orange County recused themselves. And I'll take a look at that. So,
yes.
Wow.
It's crazy. I had another friend that did it through the whole state. He actually did not let them transfer to other counties. When they transferred the counties, he made sure he was there. He looked up the names, and he made sure he went through every judge until there was nothing left in California, and then they had to dismiss. Another guy did a lot longer than I did.
Yeah,
I was trying to find out how the law worked. At that particular time, I was trying to find out how the law worked and how the courts worked. So I was using all of these particular what you call documentation evidence to find out how the law worked in California. I was trying to learn it, and that was my first. There was no license plate, no registration, no light, nothing. I took everything off the car. I wanted to find out what the officer would do if I took everything out of the car and they didn't provide nothing. All I had is my passport. I was trying to find out and learn about how the law worked, and what was the actual rights of people on the road. I was trying to learn it.
Okay, well, all right. Well, show me the proof. I'm calling BS. None of it makes any sense to me. There's more than just...
No problem. No, but you do have a superior argument, so that's why I'm kind of happy that I bumped into your site, because you actually get to the root of the problem. The root of the problem is they actually don't have the right to do any of it.
Yeah, they're criminals. I get that they're criminals, and that's why what you're saying goes against their very nature, and that's what makes it unbelievable. That's why I can't give any credibility to this. You're going to have to send me the documentation to actually prove this. The idea that somebody went and recused every single judge in California, and they accepted that because, no.
No, they did it.
Okay.
And as I'll say it again, my brother was there.
All right.
He served the document, and he's still, me and him were up in the 50s. We're way up there in age. But the point is that he was there. My family was there. They were just laughing their heads off when it came to they're trying to dismiss the case, and I kept objecting. They said, "Why don't you let him dismiss the case?" I said, "No, I want the officer on the stand. I want that jerk. He took my car. He violated my rights, and I want to put it on the public record that he violated my rights."
Well, you file a claim against the city or county's insurance, but it's not up to you whether the judge is going to dismiss because the cop didn't show up. But I would go with the demur and the motion, the demur and the discovery request and fight that scooter charge. So. But send me that evidence. I'd love to see it.
Oh, I definitely want to do that. But in the situation with my son, though, we already went through the process. We did the similar thing that you look at, except it wasn't a demur. We said a motion to strike and then a motion to dismiss, because we're striking the pleading because there's no evidence establishing that it was legally given.
And that's what a demur is for in California. But in California,
motion to dismiss based upon the fact there is no plea.
Well, you're supposed to do a demur in California. That's the way it starts. I'm sorry. We've burnt an awful lot of time with this, so I'm going to have to move on. I got a full line of calls, but definitely get me let me see the evidence. But again, with this caveat, do not send me just the disclaim, whatever it is, the recusal document. Don't send that to me unless you do it with the accompanying documentary proof of your claim that every single judge recused themselves and it had to be transferred to L.A.
No problem.
All right.
I can even pull the minutes. On that case.
Well, if they were just recusing themselves based off of something that your brother IV served the court, then that might necessarily be any minutes available. But I got to run. But I do appreciate the call, and I'm looking forward to that evidence. My email is markstevens@mail.com. Appreciate that. That's Andrew in Orange County. That makes no sense. I can't accept for a moment that just with a preemptive challenge, which is nothing I've heard of on a judge, you got to have evidence to recuse a judge. The only time you don't need evidence is like when in Arizona, where you get to a one time per plaintiff, a one time per party gets to recuse for no cause. Yeah, but that doesn't mean, but after that, if you're going to recuse a judge, you have to have grounds. I know that they usually give you the grounds, but to just walk in, I don't see any judges in California taking, Can't accept that, but I'm open to the evidence. You've been patient. We have area code 408. You're live on the No State Project. What is your name? Where are you calling from?
Hi, my name's Ted. I'm calling from San Jose, California. And right now, Mark, after that last call, I've got a really scrambled brain here.
Yeah, yeah, me too. That's why I was looking at the time.
You're correct.
What, say that again?
In California, you are absolutely correct. In California, you file a 170.6, you get one shot, and that's it. And then after that, it has to be for cause. So there was a lot of things going on in that last call that I'm just going to try to. I'm obviously interested in the pleading, but for now, I'm going to try to just take all that out of my head and get back down to what you do. Okay, now I sent you an email earlier today. I was arrested and charged with PC 115 in February of 2015. The charge is for recording a quit claim deed on a home that I owned for 35 years that was foreclosed on. It was foreclosed on, and then an outfit that was supposedly protecting my house from foreclosure apparently went in and reversed that foreclosure. So what you see on the county recorders on my property is in May 1st or May 7th of 2014, a trustee's deed upon sale was recorded by the bidder at the foreclosure sale. Then, about 20-some days later, you see a substitution of trustee recorded, followed by a rescission of sale. That enacted the county tax assessor to send me a notice of tax bill, and basically the property is now back in my name at that point. Okay. And so at that point, the property's in my name. I'm showing as holder of good record title. Okay, that's approximately May 27th. On June 13th, a quit claim deed was recorded in the county recorder's office, and that document purports to transfer or quit claim from my name to my trust. That is the document that they're charging me PC 115 for.
What is PC 115 for everybody listening?
It's a felony for filing a false document that would otherwise be legit to file if it wasn't a false document. And that the statute was written to keep people from stealing people's real property. It was intended for people who go and record a deed, not a quit claim deed, but a deed. Okay, and deeding a property to themselves and either selling it, or another thing they do is they use the recording of the deed to then show them as the owner, and they go to a bank and get a loan, and the moment they get the money from the loan, they run and they're gone, and then the real owner of the property ends up with a debt that they didn't know about. But it's also gone the other way, where the property gets sold out from underneath the real owner. But that's not what occurred here. And a quit claim deed is a release. But at this point, there's so many other things they've done wrong, Mark, and I've learned through studying your materials. I also have a traffic ticket that I've had going now for 2 years.
Jeez.
But yeah, it's BS. I just keep.
Well, what jumps out at me, Ted, is the denial of a speedy trial. They're supposed to have 180 some odd days, and if this has been going on since 2015, unless you sought a continuance, That would be one of the things I would raise. It's a felony. Well, were you indicted?
No, that's another thing, Mark. I've talked to a lot of criminal attorneys. I did not waive indictment, and according to the federal rules of criminal procedure, Rule 7 precisely, that if you don't waive indictment on a felony, then they have to get an indictment.
But you're not at the federal. The federal rule is not applicable in California.
So how this came about was by information. A violation of PC 115 by information. The problem with that is I see no competent fact witness. I see there's no affidavit or declaration from anyone. There was a complaint form, is not signed or dated. And that person that filled out that complaint form has no firsthand knowledge or eyewitness knowledge. I don't think they have a valid arrest warrant. And as you know, I sent you another email today. All of this resulted in me being taken out of my home by the SWAT team and over 25 law enforcement. Well, I got to get more into the story here, but I'll keep it short.
We're going to have to because I don't have much time left in the show, and I've got a full boat of calls.
Well, what happened was this: I was fighting the foreclosure and the eviction from my home of 35 years, and I was being pretty successful. And then the courts flipped it over to this corrupt judge. And he made orders. I removed the case to federal court, and I told him the case is in federal court. And he went ahead and made they held some hearings without me and made some orders to get me out of the house. And so I got wind of it, and I named him in the federal lawsuit. And then I went to the FBI, and I told the FBI, you need to watch this guy. And a few weeks later, the SWAT team came out. They took me to jail. While I was in jail, the guy that bought the house foreclosure sale cleaned out my house of 35 years. And then I had a heart attack, and I'm in the streets, broke and homeless, and they counted on me either dying or not being able to defend myself. I had a public defender on the criminal charge for the first 8-9 months. I kept trying to get rid of them. They wouldn't let me get rid of them. Then I've now read the judge's bench guide on felony arraignments, and I see that they violated my constitutional and civil rights about 5 different ways in the arraignment.
Well, there's a lot to unpack here, and I don't have that much time on the show left. You tried to do a removal to federal court of a criminal proceeding in the California...
No, the civils. The civil. That's why I was winning the civil, and that's why they came back and put this bogus criminal charge on me.
You know, something like this. Just it's a little bit different, but there's a lot of parallels to what happened with I think it was Kim in Cincinnati on the Saturday show, where she went into what looked like abandoned properties and made improvements and turned utilities on and was improving the homes. And she had filed quiet title actions. And next thing, and then a while after that, even though she actually had somewhere they won, county attorney filed an indictment, charges against him, criminal charges for unauthorized use of property, tampering with records, and similar to what's going on here.
That's a little different, though. This is my home of 35 years.
Well, right. I'm just saying that it's where you're in a civil proceeding trying to settle the title on the property, and you're getting hit with indictments. You're getting hit. You're being charged criminally here.
No indictment.
Well, all right, but you're being charged criminally. You don't have to be charged by indictment in California. You can just charge you by complaint. At the federal level, all crimes have to be by indictment, unless I guess you're able to waive that. I don't remember. I don't remember that. But at the state level, like Arizona, California, they could just hit you with a complaint, which is why you get a preliminary hearing to determine probable cause when they do that, because they did not indict you. There was not a finding of probable cause by a judge. So,
well, that's correct. That's if you have an indictment, you don't get a preliminary hearing.
Right.
But so you mentioned something about 120 days to prosecute. I'm looking for a way to end this. Let me tell you, I fought them so hard. I even did a writ of habeas corpus that was denied, or actually it was just denied by the appellate court. I took it to the federal court. They dismissed it the same day they got it. And by the way, the appellate court that I put the habeas with, but their own rules say they have to give a reason. They gave no reason. And so I appealed it to the federal court. The federal court dismissed it the same day they got it. And so now I have it up at the Ninth Circuit right now. Now, the DA is sounding like they want to dismiss everything now. But I'm looking for something to do that just finally convinces them, puts them over the top. They're there right now. They're talking about, right now dismissing everything. And I'm representing myself. And what they want me to do is they want me to go back to the last lawyer I had and work through him. I hired a private attorney to get rid of the public defender. That's the only way I could get rid of the public defender. And the private attorney represented me through the preliminary hearing. He felt so strongly I was innocent, he did a 995 motion pro bono, which should have been sustained, because they gave no evidence at the preliminary hearing. None. They submitted the quitclaim deed and gave no testimony to it. So basically, the record shows nothing entered, period. And so he was strongly saying that, hey, it's over. They screwed up. But the judge said, no. He's the only one that benefits from this. Well, I'm not charged with recording the substitution of trustee or the rescission of sale. And those may be illegal, but that's not me. So back to what pleadings could I file right now? I think I'm looking at your traffic ticket process, and I'm considering doing the same thing. It comes down to jurisdiction, and they don't have it.
Well, I would still, I would push on the discovery request to get the evidence from the prosecution, and maybe then move for a dismissal for prosecutorial misconduct. I'd put in there, though, I think unless one of these attorneys, and you're going to have to find this out, unless they got a continuance for you or you did that, speedy trial rule should, maybe enough to get this thing tossed out.
Well, at my first arraignment, they brought in a retired judge, a ringer. They did this because they knew I wasn't going to plead. But I read the judge's bench guide. It says that if the defendant's not ready to plead, that you must continue it for at least 1 day. It's a hard rule. Also, so he didn't do that. He screamed and yelled for a plea from me, and then he entered a plea of not guilty. And then I said objection, and he started screaming and yelling again, saying that I cannot object. And then he says, do you waive time? And I didn't say anything, and he started screaming, it's not that hard. It's blah, blah, blah. And in the judge's bench guide, there's something similar to a Miranda statement that they're supposed to give to you about your rights and giving up your rights to a speedy trial. I've seen them give that to all kinds of other defendants. I've been in court now 40 times on this case. I've been hauled into court 40 times on this case, and I've watched. And whether they're represented by the public defender or have a private attorney, every judge has asked every defendant, do you understand?
Right.
And do you give up this right? I was not given that.
Okay, but did you waive? Did you give? Did you waive time?
That's what I'm getting at. No.
Okay, great. Well, Well, Ted, it's just that I have a line of calls, and I'm pressed for time. I apologize that I let the first caller go on so long, but I would do like what you were already thinking of doing. I would file the demur. I would file the discovery request as soon as possible, give the prosecution a few weeks, and if they don't respond, then I'd file the motion to dismiss for prosecutorial misconduct. Really do what I can to hold his feet to the fire. Because the demur is look, if they don't have the evidence to support the claim, they can't just assume an essential element to the charge. You can't just assume that the rules apply, and they have to have actual evidence. So that's what we have set forth in the demur, and that's the way I would do it.
I said in response to do I waive time, I said, I see the public defender nodding his head. But you see, they have to first ask me, do I understand what was just said, and do I understand giving up my rights? They didn't ask me that. Okay, so they screwed up the arraignment right there.
Well, they would just overlook that, and it may still be an error, but it may be an error as far as ineffective counsel, because your attorney was required to explain what the implications were of that plea. So,
well, remember, Mark, I also went to a subsequent hearing. I had a heart attack after that.
I don't blame you.
I was 5 weeks. 5 weeks after the heart attack, I was ordered into court against doctor's orders. Are you there?
Yeah, I was just thinking. With the first caller, I almost had a stroke. So I can understand you having a heart attack after this.
Okay, so yeah, and believe me, I was sitting there trying to take deep breaths. But anyway, so they ordered me into court 5 weeks after the heart attack. I began to suffer a second heart attack. The judge was in her office. They had her come out of her office, go back on the bench, and continue to prosecute me. After 9/11 had been called, paramedics and ambulance on the way, they continue to prosecute me while I'm having a heart attack.
Yeah, they don't give a damn, and I'm really sorry to hear that. The best I can do now is put the pleadings in and give wait a few weeks for the prosecutor to respond, and take it from there.
Well, I mean, it's unbelievable. Santa Clara County is I would say is the most corrupt county in this state.
Everybody says that. People will say Orange County, but they're all bad.
I know they all.
They're all bad. Hey, you could have just, maybe just try to get the judge to recuse every judge in the county. Maybe that's the way to go. I could have. That wasn't at your expense, but that's the best I can do for right now. And so, I have more time on Saturday shows. So if anybody's got a long narrative like that, this is typically not the best format for us to handle that, because I just can't dedicate the entire show to two callers. I've got a whole bunch more I need to get to.
I understand, Mark.
I do appreciate the call, but get those filed and stay in touch. Let me know what happens.
Saturday calls the same number and everything?
Yes.
At what time?
1 to 4 Pacific time.
Pacific time. Okay, because can you...
Well, it's all on my website. Ted, it's all on my website. All the information is on markstevens.net. Okay? All right? I got it. All right, so I appreciate the call. We've got area code 912. You're live on the No State Project. What's your name? Where are you calling from?
John.
John.
Argentina.
I'm sorry, from where?
Argentina.
Wow. Okay. I think you're the first one from Argentina. Welcome to the show. What can I help you with today?
Mark, I spoke with you the other day on the deal with my house in Georgia, and I got word back today from the attorney. He wanted to start making a deal.
You heard back from the prosecutor?
No. This was the other attorney. Remember where my house is? They had the damage, property damage.
Right, the property damage and the easement.
Right.
So the other attorney called for the attorney representing this awful neighbor?
No, it's the attorney that was representing the city of Hinesville.
Oh.
Actually, it's a contractor who works for. They've got a $9 million contract with the city of Hinesville, And anyway, they contacted me today, wanting me to talk to them about getting my invoices together, which I'd already sent them that, and I shared those emails with you too. I think it was last Friday.
Okay. So what does the attorney want?
He's offering 1/5 of what the actual damages were, and it just doesn't sound right. And I didn't know when we last talked. You said something about you would try and contact them and see about getting the insurance for me to maybe make the claim against them, but they were stonewalling me.
Right. I have not had the opportunity to do that, so I apologize. So I'll do my best to get that tomorrow. Well, obviously he's going to lowball you the first offer he makes.
Mm-hmm. And I knew that.
Well, and so what was your response?
Well, my response was I sent him back another statement of claim. This time I went through and I actually added all the invoices, and I had originally told him it was $15,000 because I was trying to get in on the lower court. And when I added everything together, I said, it's way over that. I think I was being pretty fair when I offered you a claim for $15,000. And the actual amount of money that I've spent repairing the damage that you all caused by negligence was in excess of $23,000. I've got invoices right now that I gave you for $18,000 today. If you want me to keep counting those invoices, I'll be more than happy to do it. And he said he was going to contact me later on. He wanted to talk to his clients.
Well, you're going to have to go through this bargaining process, this negotiation process before you can file a claim. Because if you file the claim now, it's not ripe. I mean, we have to do everything reasonable to avoid going to court. So if they're coming to the table, if he's not going to, so you go through and you try to negotiate this. If they're not going to budge, then you have no choice. They're not dealing with you in good faith, because if it's 1/5 of the damage, and you can document the damage, yeah, that's not a fair offer. So at least you've done everything.
Right, and then he wants me to also give them a new easement for the amount of the property, another 3 foot by 7 foot into my property, because they mismeasured it to begin with. He wants me to give him that easement for free, or he said maybe sign an agreement for $2,000 for indefinitely for a permanent easement.
Well, hey, I would say settle for at least close to the 23 that they've damaged you, and should be a problem. Just take another $2,000 for the easement. But they're going to have to come up. I mean, 1/5 the damage, that's just not going to cut it.
Yeah. Well, that's what I thought, too. I just I thought I'd see what you had to say about that. And
at least they're coming to the table.
Yeah, they still are stonewalling me. When I tried to get the information for their insurance agent again today, they stonewalled me again today. I talked to the one lady, and she said that she would give me a call back. I left a message for another one, Sarah Lumpkin, who was the county clerk, and she never gave me a call back. But, yeah, they are at least coming to the table now, so that is a step in the right direction.
Yeah. And for those who aren't familiar, the clean hands doctrine, or the rightness doctrine, where we have to do everything reasonable to avoid going to court. The court is a drastic last resort. They don't follow that. They just haul you immediately into court. So that's because judges are going to look the other way. But if you and I try to pull that stuff, that's probably what, if you were to file a claim against your insurance now, they would just, we're in a negotiation process. It's kind of premature. Don't, see how that goes. And you certainly couldn't file in small claims right now. So, yeah, see if they, make them a counteroffer and see where that goes. But I'll do my best to get in touch with Hinesville tomorrow and get that information about the insurance.
Okay, well, appreciate it. I thank you very much.
Hey, I appreciate the call. And, yeah, John in Argentina, thanks. Let's see, we've got, he's been on the show before. We've got Jermaine in Alberta. Jermaine, welcome back. We're going to go a little bit over on the show today. I can go a little bit over.
Hey, what's up, guys?
Oh, man. We got some background noise with you there.
Yeah, I'm just traveling right now. Can you hear me clearly?
I can,
Oh, okay, great.
but but you got to turn the feed off.
There's a background feed.
Well, I can hear. Okay, it went away. Okay, so what? Okay, so all right. Anyway, you got an update for us? Good news?
Sort of and no. Basically, right now I'm trying to finish filing this appeal. Right? They've been dicking me around. What happened is I was trying to waive the transcript fee, right? Because it's quite expensive for transcripts. And so I had a motion hearing for that last Friday, and it of course was denied. And how they did this is they set the motion hearing right on the last day, like the 30th day for my appeal, and it was denied. So this week I've been trying to get an extension of the appeal. So I'm just leaving the courthouse right now. That's why I said I'm traveling, and I filed another motion to get it in front of a justice to extend this appeal date. And what I did is I ended up just, paying for the damn transcripts. I got a digital copy, it cost $45. And so I filed it today, and now I'm just wondering when I go there, how should I approach this so that I can get them to extend? I only went over by 2 days, right? So how can I approach this so I can get them to extend the appeal deadline and accept my motion?
Because you had a motion pending about the transcript in the lower court, so it shouldn't be held against you. That's really the only thing I can think of.
Yeah, and that's exactly what I thought. Because I put the correct motion. I did it all within a time frame. I have everything. I kept all my documents. They're all dated, and they're all within the 30-day time frame. But of course, I went over by 2 days because they denied my motion to waive the transcript fees. And then so I decided, hey, I'll just, I'll pay for it, even though they could give it to me for free. And they have several times in the past. But this time they kept stopping me. So, that's where I'm at. I'm just finishing up this appeal process.
Yeah, that's the way I would do it. We had a it's down here in Phoenix. We had someone, we missed a filing date, and they consider that jurisdictional. And, if they don't budge, they don't budge. You're screwed. You have to file a petition for a writ. And it's very iffy that they'll take jurisdiction over that. So, yeah, that sucks. So hopefully that'll be enough, and they see. It's just like one time I got pulled over for a traffic stop on my way to court. And I said, "Excuse me, you're making me late for court." He says, "Well, you got a damn good excuse." Yeah, he said, "Well, you got a damn good excuse. Give him my badge number and give him a copy of the ticket. They'll understand." Yeah, you prick. So that's the best I can do for right now, Jermaine.
Yeah, no, thanks. I don't want to take up too much time because I know you got a bunch of people there. So I'll call you back in a couple of weeks and let you know what happened. Yeah,
and you can definitely let me know on Skype what happened.
Yeah, sure.
All right. Appreciate the call, Jermaine.
Yeah, take care.
Cheers. All right, we got one last call I can get to and go a little over here. We have Enrico from Los Angeles. So we'll start it with California. We're going to end the show on California today. So what do you have?
Hello, Mr. Stevens. How are you?
It's like I felt myself having a stroke during the first call.
Man, I hear you, man.
I got people chatting thinking that he's just he's just trolling me, and I kind of,
Oh man, well, I guess it is what it is, I guess. But anyways, man, I'm calling with my new situation.
A new situation?
It's pretty messy. It's pretty messy, to be honest with you. The last time I was calling was because of my, it was a ticket that I had gotten on federal grounds for $1,500, the drivers without a license, and I got taken to court, and I feel like I did it the wrong way. I guess you could say the sovereign citizen way, And
this was recently?
Man, I think it's recently. Yeah, it's recently. It's actually before I contacted you. It was one of the. This is for another case. So the one that I went, the one in the federal district court, man, they ran me over. I'm gonna be honest with you. They ran me over.
All right, because I was gonna say if you if you had done the sovereign citizen stuff or the sovereign stuff after speaking to me, I think you would have completed the stroke that was started in the first first part of the show.
I didn't go that route.
Good.
Pretty much, but I think that's why they didn't do anything or say anything. But pretty much I tried to stay with the script. I told them where they'll probably lie, who's the victim, standing, all that, and she pretty much objected to anything that I said. And then I gave a little opening statement. I did the one thing I did. I'm not gonna lie. I did as my opening statement. I did say, I'm not here as a corporate vessel under maritime. I'm here as a human, and I'm not a person. I did say that. I'm gonna be honest with you. That was my opening statement. All she said is, okay.
Come
like,
on.
She's like pretty much one ear, one out the other. So
well,
at
sure.
that point, man, yeah, I know. It was a little nerve-wracking, but...
So let's wait. So you want to set the stage for this trial by doing something stupid.
I did. Oh, man. That's the only thing they said. But to be honest with you, it seemed like I'm going to be honest with you, I felt like nobody even heard that.
No.
Man, they just went along with it.
No.
Yeah, they just went along with the show. Like, I ain't going to lie. They went along with the show, and then they said, okay, well... let us call the witness. We start.
They heard.
They called the witness. So I try to impeach him. I try to go with the valid cause of action. But I guess the way I was saying it was too in the legal matter that I was doing it so bad. So I I was so stuck at the moment I wasn't able to think it in a different way how to describe it, to get the answer from. So
did you? Well, Enrico, did you do role playing in the No State Project Skype chat?
I'm gonna be honest with you. I know. Tried a little bit, but not too much.
Yeah, I could. Yeah,
it was very difficult. But anyways, the judge objected to everything I wanted, and then they even had a DMV expert. I was trying to argue this paper that they gave me about non-commercial and commercial paper. That was a non-commercial. They didn't even hear me out. And at the end of the road, I was found guilty. I'm going to just be honest with you. I said, I asked for remedy at the end, and they said, this is we're too ahead of the hearing to give you remedy. So, found guilty, bam. And then I really thought that they were going to give me the max, because that's what they were seeking. They wanted 1,000 to 6 months, because I had said a lot at the beginning, or whatever. But apparently they just wanted $100, so I just gave them the $100. For whatever reason, from 1,000 to 100. Yeah, it was. I said, okay, here you go. Even though it was I shouldn't have. I saw.
Well, you did a lot of things wrong, but I'm glad it was only the $100. But please, for everybody listening, just for you and everybody listening, don't mix the stuff. If you're working with me, do the role playing, and please, for heaven's sakes, don't do stupid things like talking about being, the flesh and blood man. You're not a corporate entity. They're not accusing you of that. And if you are so certain that they are, ask them a leading question. Are you coming after me as if I was a corporate entity? Is that the basis of your jurisdiction? You just ask them. Oh, well, I'm totally out of time. I do need to run, and I had a tech issue that will be apparent when I upload this video.
It's all
hey, don't sweat it. Just if there is something that does happen again, you got to do the role playing, and if there's an issue
it was a very good learning experience for sure. And to be honest with you, the judge she was very lenient, and she was actually helping me out with a few things. And she was to be honest with you, she was a very nice lady. I'll be honest with you.
Well, for how judges go, she probably felt sorry for you. Yeah, I think she probably just felt sorry.
I was speaking to the attorney before and even after, and they were okay. I think that's why they said just give them $100, man. Just charge them $100. I was like, here you go.
Well, I'm glad that's all it was.
It was a learning experience.
But let's make sure we prep next time and stick to just challenging the prosecutor. All right.
All right, for sure. I will do. Thank you. Appreciate your time, and you have a good day, okay?
Thanks. Appreciate the call, Enrico in Los Angeles, and that will bring us to the end of another broadcast here on my YouTube channel, No State Project, and episode 43 of The Big Show. And That's why I say it's so important to do the role playing, and so that you not only know the concepts, that you're just asking questions and holding the prosecution to the burden of proof, but so that you'll know how to respond in real time, and that it won't be new to you. You'll know that no matter how stupid of an evasion, how stupid of a thing that they say, you'll know how to respond by relying on the Socratic method and just asking leading questions to bring out contradictions. When you know they're full of crap, it's easy to ask questions to bring that out. But bringing up this thing, I'm not the flesh and blood man, now, that was one of the few things they probably did listen to. It's after that they can then ignore you. But when you start coming in and you lay the groundwork that you're some kind of sovereign freeman on land kind of type, no, they're going to just zone out the whole rest of your so-called defense, which is, but then it was only the $100. Don't mix the stuff, though. If you think that there's merit to this sovereign stuff, don't use my material, please. Do one or the other. Either do it rationally based on logic, and holding the prosecution, holding the accuser to their burden. Or just go the other route and try to get some success with this crap that you're not the corporate person, you're not the all caps. You're just the administrator for the Set Askew Trust, and that you just want to use your treasury account to settle it. I'll accept this for cause, or accept it for value. Give me a break. Reason why we've been successful is because we just hold the prosecution to their burden of proof. And that's why at markstevens.net, hopefully we'll have Brady's new documentary proof that we can add, where we have actual documentary proof from courts, administrative agencies, and the Internal Revenue Service and other taxing agencies. We have the proof to show that our defense was effective, that they dropped it for lack of evidence. And this is why I seriously doubt that Andrew is going to be able to provide documentation to prove that the head judge, the presiding judge of the Superior Court in Orange County, not only recused himself, but every single judge recused himself on a preemptive challenge. Nope, not buying it. Not buying it for a second. And I doubt there's going to be any evidence to that. But, again, like everything else we talk about, I talk about here on the show, hey, if the proof is there, I'll accept it. But I'm calling BS on that. But this has been episode 43 of the live edition of the No State Project, live from the Fortified Compound in Mesa, Arizona. I will be live on Saturday, so whoever we missed today, definitely call in for that. And until then, salud.